I'd like to introduce Dan Schmutter at this point.
Thank you, Frank. Thank you, Frank. Thank you to Frank and Bob and the NJ2S for inviting me here. It's very kind of them to ask me to speak. I have a little chart here. I promise it won't be a quiz at the end, but I'd like to use this as a kind of a jumping off point for my comments. And I'll show you why in a minute. A few months ago, I was speaking at the annual meeting of the Association of New Jersey Rifle and Pistol Clubs, the ANJRPC. And I said something which I actually never expected to say. And I think some of the people who were listening to me never really expected to hear me say that. And it was a little shocking at the time. I think Frank, you were there, and Bob may have been there as well. I said that it's a very exciting time to be a New Jersey gun owner. And, seems a little strange, but it's actually true, and I want to explain to you why I said that and why I believe it's to be the case. And I want to start with this quotation here. I hope you can all see it. If you can't, I'm going to read it to you anyway. This is a quotation from a decision called Burton versus Sills, which was decided by the New Jersey Supreme Court in 1968. Now, I'm 46 years old. I was born in 1964. So this case was decided 4 years after I was born. And the way this case came about was that, many of you may remember, in 1966, that's when we got our gun control law in New Jersey. Now, there's been gun control for many, many years in New Jersey. There have been permit requirements and all sorts of license requirements since the 20s. But in 1966 is really when they handed it to us. 1966 is when we got the comprehensive, full-blown gun control law that we know and love today. And although it's been modified and it's been added to, we have smart guns, we have all sorts of other, assault weapon bans. But the 66 law, that is the fundamental basis of the regulatory scheme that we all live with. So this case was a challenge to that 66 law, and it went to the Supreme Court, and one of the arguments that was made to strike down the law was that it violates the Second Amendment. Now, in 1968, we also had the Federal Gun Control Act. So 1968 was not exactly a red letter year for the Second Amendment, and what the New Jersey Supreme Court said, rather with a wave of their hand, is there is no right to keep and bear arms under the Second Amendment. And what they said literally was regulation which does not impair the maintenance of the state's active organized militia is not at all in violation of either the terms or purposes of the Second Amendment. Now, I think we can all understand that in 1968, the Second Amendment was largely a dead letter. People didn't think it meant anything. People that mattered in the sense of people in government, judges, scholars, were all convinced and had been convinced for generations that the Second Amendment was a militia right, it was a state right. Individuals like you and me had nothing to do with the Second Amendment, and the New Jersey Supreme Court said so, just like courts had been saying for decades before that. Well, now let's fast forward to 2010, okay? I've juxtaposed another quote below, the Burton versus Sills quote. And that's from McDonald versus Chicago, and Bob talked about the McDonald case. As I'm sure most of you know, in 2008, the DC versus Heller case, the Supreme Court announced for the first time that the Second Amendment does, in fact, guarantee an individual right to keep and bear arms, contrary to what so many people had been saying for so many years. And the McDonald case was 2 years later, which applied that same rule throughout the country to state law, local law, federal law. So now, after McDonald, we know that it applies to everybody and everything. And in the court in McDonald versus Chicago said, the Second Amendment protects a personal right to keep and bear arms for lawful purposes. What's amazing to me, and really this is sort of what I want to talk about tonight, is how did we get from here, just 42 years ago, to here? During my lifetime, I'm 46 years old, and during my lifetime, we started off here, and now we're here, which to me is extraordinary. I'm kind of amazed at how quickly, I'm not going to say easily, but I'm going to say quickly, to go in a mere 40-some-odd years from that, which really is a statement that the Second Amendment is essentially written out of the Constitution, to this, which is essentially a robust, a strong, a vibrant right to keep and bear arms that serious people are now taking seriously. How did that happen, and what does that mean going forward? And that's really important. Now, you know, one thing that we've learned in dealing with Second Amendment advocacy and Second Amendment litigation is we've learned from the Civil Rights Movement. How did the Civil Rights Movement come about? The Civil Rights Movement came about through relentless but incremental fight. It is small but consistent steps year after year after year after year after year. You're not going to just jump into court, say to a judge, I have a right to keep and bear arms, therefore I shouldn't go to jail for possessing a firearm. Judge is going to look at you and say, I don't know, everything I've read says that it's a collective right, or it's a militia right, or it's a state right. So how do you get judges, legislators, and people generally to understand what the Constitution really means and what the Second Amendment is really all about? Well, it turns out that like the Civil Rights Movement, it is this long, persistent process, and it started decades ago, and the first place it started was, believe it or not, with scholars, academics. What we've seen over the last several decades is serious scholars, law professors, economists, historians, sociologists do serious research and uncover the history behind the Second Amendment, the history of the Constitution, and what we know now to be the case about what the right to keep and bear arms is. I mean, we've had, over decades, we've had Steve Halbrook, Dave Kopel, Eugene Volokh, Bob Cottrell. I mean, people like that doing the really, really hard legwork to dig and dig and dig and find out what the Second Amendment really is all about. Because for so many years, people have been saying this, when we all know that it's really this. Well, now that we have had all these years of papers and presentations and seminars and symposiums of people taking the Second Amendment seriously, suddenly you have this sort of a foundation upon which people can actually now take this seriously. Well, then what do you need after that? Well, you need organizations and you need grassroots participation. Okay, so what do we have? Well, of course, we've had NRA for many years. NRA is the largest organization. It's the most well-funded organization. They're into a lot of things. They're on Capitol Hill. They're in the local legislatures. And, they do an awful lot of stuff. But we have more than NRA. Why do we have more than NRA? We have more than NRA because it's always valuable for people to give their perspective on the right to keep and bear arms, on the shooting sports, on the importance of all this stuff. So we also have SAF, Second Amendment Foundation. As we know, they're funding all sorts of lawsuits all over the country. We have Gun Owners of America. We have local organizations like the Association of New Jersey Rifle and Pistol Clubs. I mean, that's an organization in New Jersey that does an enormous amount of work here in New Jersey. The president of the ANGRPC, a guy named Scott Bach, a lot of you may know him, possibly the hardest working human I've ever met in my life. The man is just relentless. And it's ANGRPC has their own perspective on things. You have even smaller organizations. As Frank indicated, I represented Jews for the Preservation of Firearms Ownership, JPFO, in a number of Supreme Court cases, including Heller and including McDonald. JPFO is kind of an interesting organization. I don't know if you're familiar with it. Actually, we just recently lost Aaron Zellman, the head of the organization. He passed away at the end of December. And he's the kind of guy. He was the kind of guy who was never at a loss for some idea. JPFO was kind of known as one of these organizations that was kind of out there at the edge. Sort of the opposite of NRA. NRA is very mainstream. They're very respectable. They go to Capitol Hill and people take them seriously. JPFO is a small organization, not a lot of money, and just out there, just saying stuff. And sometimes you just got to say stuff. Sometimes you just got to say what you mean, what you're thinking. And Aaron never was at a loss for words. I remember, he would always constantly email me. While even between the Heller and the McDonald cases, he would constantly email me and say, "Well, what about this? Can we try this? Can we do this? Can we bring some kind of lawsuit? How do we make this argument?" He was never. He was constantly. His mind was in motion. And the reason for that, and the reason you need that kind of stuff, is because you need people having different perspectives. I can tell you, Aaron Zellman and NRA on the other extreme often did not see eye to eye, but that's okay. That's actually really important. You need to have different groups and different organizations and different people doing and saying different things. And I mean, look, we're here today with NJ2AS. Somebody may say, well, why do we need another organization in New Jersey? And the reason we need another organization in New Jersey is because the people in this organization may have different ideas and may be interested in doing different things. Bob just mentioned a whole series of initiatives that this organization is doing that, you know what, maybe someone else is not doing those things. And that's how this lays a groundwork for ordinary people like you and me to just say things, do things, talk about things, listen to people, meet with people, and create an atmosphere where people can take this seriously. And we've had that for a long time now, and it's growing, and it's building, and that's another critical component of why we are where we are today. What else do we need? Well, you need tacticians, strategists, you need lawyers, you need people to think through the logistics of vindicating the rights. You know, you can't just, a historian can publish a paper about the Second Amendment, but that doesn't give you your rights. That doesn't get you out of jail if you're arrested for possession of a firearm. It doesn't give you a license to carry if you think you have a right to do that and your state is denying you the right to carry, like here in New Jersey. So what do? You need lawyers, you need people who can think through the tactics and develop the strategies to get us where we need to be. And what's the last thing you need? You need judges who understand this stuff and are willing to make the right decisions. It used to be really easy, it's actually still really easy in a lot of places, but it used to be incredibly easy as a judge to get a case before you where someone claimed that they had a right to keep and bear arms and that the Second Amendment guaranteed that right, to say, well, that's not an individual right. Everybody knows that that's a collective right. Sorry, you're dismissed. Get out of my courtroom. It used to be really easy to do that. And like I said, it's still easy to do that, but what we've got now is an awful lot of judges that actually take this stuff seriously. They understand the history, they have access to the scholarship, which is where that's important. They have access to the arguments that people can convince them that the right to keep and bear arms is real, it's individual, we have a right to it, and it's meaningful.